Mbombela keeping a close eye as Matthew's Posa hits the campaign trail for the African National Congress. So former President Jacob Zuma and the Umkhonto weSizwe party have called for 6 Constitutional Court justices to recuse themselves from hearing the IEC's matter involving the former president. The court is expected to hear the Electoral Commission's application on Friday. Now, the IEC is seeking clarity from the court on its implementation of the Section 47 of the Constitution. This is the same law that the IEC used to disqualify Zuma from the 29th May ballot. But that decision was overturned by the Electoral Court, prompting the Commission's appeal to the Apex Court. Now, according to Zuma, Chief Justice Raymond Zondo, alongside judges Madlanga, Majiedt, Mhlantla, Theron and Tshiqi, are all tainted by bias and are therefore not fit to hear the matter involving him and his new party. Well, for more on this, we get some analysis from legal analyst Mpumelelo Zikalala. Mpumelelo, good morning to you. Thank you so much for joining us. Let's start here. Are you surprised by this move by the former president?
Not at all, but I'm a bit surprised that it was done at this early. I think maybe he ought to have waited to see how the court is constituted, or to have waited what the Constitutional Court would have done in its wisdom. I think the court would have seen that this is a matter which is coming back to us. We issued this particular sentence, so we cannot then rehear or hear a matter which pertains to us. Let us borrow from the judges of the Supreme Court of Appeals or any other judges that are in South Africa, appoint them on an interim basis and allow them to hear this particular matter. But it was a bit surprising that it is raised at this early stage. Yeah,
but this is the argument that the former president is essentially putting on the table. He says that these 6 justices essentially were part of the bench that convicted him and sentenced him to 15 months for contempt of court. That was for failing to appear before the State Capture Commission. And so there is a conflict of interest. Does he have a fair point?
Not necessarily a conflict of interest, but there might be a reasonable apprehension of bias towards whoever would be faced against the former president. Remember, the test for apprehension of bias is to say, I, as a person who is the subject of that particular matter, am I going to be treated in a fair manner? Have I got the confidence in the adjudicator that they're going to look at my matter in a fair process? Now, they found me guilty previously. I then stated a number of times, even in the media, that the manner in which they've conducted themselves were not proper. So I'm not going to trust them in dealing with any matter that pertains to me, especially when there's a close nexus between what they're going to decide on and the manner in which they've treated me previously. So it is on those bases in which I think the former president does have a point. Not in a conflict of interest, but a reasonable apprehension of bias.
But is there, I mean, let's talk about what the law actually says there in Mpumelelo, right? I mean, is there something in how the law is structured that a judge that presided over a particular matter, a different matter, cannot preside over a separate matter, even if it's involving the same person?
The law looks at it from the person who is making the complaint, who's crying about the biasness that is there. And it says to us, look at it from a subjective factor. Do I trust that the individual who is sitting up there, who's going to decide my matter, is going to decide it in an objective manner, in a manner that there's no element of biasness in any way? Now, you then go back and say, how close are the principles of law which are being looked at? The start or the ignite of whatever that is being discussed is a sentence that was issued by the same court. So then it then says you are indirectly asking the people that presided over the matter again to then give further clarity as to what they meant about the sentence. Does it fit into the definition of a sentence as per Section 47, for example? You do not want those particular judges to go into the realm because they've decided the matter, it was seized with them, it was done. You want fresh eyes, a fresh mind who's going to listen to arguments and be able to determine the legal principles as they are applicable in South Africa.
Yeah, so what are the options then for the Constitutional Court? I mean, the court essentially needs a quorum of 8 of its 11 judges to preside over a matter. So let's assume that he does get his way. The 6 judges then do recuse themselves from sitting in this particular matter. What then happens?
Then what you can do is that you can appoint any judges on an acting basis. Maybe what they would do is that they want to balance the scale. Maybe let's take half of the judges from the Supreme Court of Appeals, another half of the judges from the different provincial divisions that we have. bring them together, make the quorum and say to them, I'm appointing you on an acting basis.
Okay.
Can you please come and act in the Constitutional Court so that you can be able to deal with this matter? It is one matter going to be dealt with very quickly because we need a decision by the end of the 29th of, before the 29th of May. So I don't think it's going to disturb them in their normal duties in their respective courts. So it is not that much of a conundrum. It's just a simple fact of appointing acting judges, calling them up to come and act in the Constitutional Court, let them hear the matter, and then they'll be able to adjudicate it accordingly.
Okay, so that sounds doable, but the time frames, right? Let's talk about that, because essentially this matter is set to be heard on Friday. Can the Court make all of those moves in the space of, what, 6 days?
It would depend on how the court rules of all the other courts are tight.
Right.
So you have to go back and look at the SCA and say, in the SCA, how many matters do you have that have been set down? Do you have people that are available? Let's look at the various divisions that are there. Let's also consider them. Remember, the Chief Justice also has the option of appointing any legal practitioner that has the right qualification, that has the right type of acumen and the experience to deal with this type of matters, to say to them, come and act. So when it comes to the shortage of judges, I don't think they'll have a problem with dealing with whatever queries that the former president might have, despite the fact that it's a short amount of time. And in fact, what would be to the advantage would be the fact that this is not a matter which is going to be heard for a week. It's a one-day event. Come back, deal with judgments, maybe 2 for 3 days, and then you are done and dusted. So we only need you to take you away from your normal court duties in any court that you are in for a maximum of 5 days, and then you can be able to go back and continue with your work.
Is it possible that the former president perhaps is concerned that he may not, get the outcome that he really wants to see on Friday in the Court? And essentially, I guess what I'm asking you is, when you look at Section 47 of the Constitution and what it says, do you believe that the president has a case here, and that essentially he might able to be successful and stand in the candidacy?
I think from his side, is coming from a point of saying that I do not want this decision to be tainted by the historical context. So I don't want individuals that presided over the matter, have intimate knowledge, to then come and justify the sentence that they gave me, which I still believe is wrong, according to his statements. But I want a fresh legal mind, fresh presiding officers to come and deal with the legal principles of what we are dealing with. In terms of the merits of the matter, I seem to align myself with the second judgment of the Electoral Court that says you have 2 instruments which have been utilized by 2 different people. Yeah. You have the judicial service, the judiciary that has the power to issue out orders. They've done so. And then you have the Constitution, which according to Section 2 is the supreme law. That means it trumps all the other laws, even what the legal principles will then be able to be applicable to judiciary. So if the president is giving those powers per the Constitution, it is up to the president to say, I want to apply these particular powers sparingly, in an intelligent manner, because I do not want to trump any other legal principles that are there. We are dealing with an after-the-fact type of matter. The remission was issued. Let's deal with the effect of that. And the effect simply means whatever sentence that was issued by a competent court has been reduced. If it has been reduced, it falls under the Section 47, then a particular individual is eligible to stand and be part of the list that goes to the National Assembly. Yeah,
okay. Do you believe, I mean, we did see that Justice Raymond Zondo has announced publicly that he wouldn't sit on cases that involve former President Zuma. Do you think that perhaps saying that to set this precedent? This precedence, yeah.
It may have, but I think where he was coming from is pure legal principles, and it has nothing to do with other factors that may be there. Right. That says, I'm closely linked to this particular individual. We may like or may not like each other, but legally speaking, there is a reasonable apprehension of bias which is subjected to him that says, I may not like him, and I'm not going to issue orders which are in his favor. We're in this position because it's one of the applications that I initiated. We're in this position because I'm part and parcel of the merits of the matter and how, or the facts that may be considered at a later stage. So in order for me not to change the outcome, to make sure that the outcome is pure and there's nothing wrong with the outcome, let me remove myself and let independent presiding officers deal with the matter. And then on that basis, maybe you can have the reassurance that the manner in which they have looked at is something which is beyond approach, and it was purely done not in anything else, but based on legal principles, case law, and even international law.